Brian.
Hi.
Hey, Brian.
Yes.
Hey, FYI, we have everybody here tonight, including the alternate. The alternate participated in the continued hearing. So
Okay.
we're going to be playing musical Who's Hearing What Cases tonight.
Sure. Understood.
Paul, we ready? Okay, Mr. Chairman, we're ready.
Thank you, Steve. Good evening, everyone. This is the meeting of the Hagerstown Board of Zoning Appeals. Tonight is June 16th. I apologize, I can't be there in person, but I hope we'll be able to get through this without too much technical difficulty. First, I'd like to introduce the persons who are present with me tonight. We have Janice Kelsch, who's appearing by Zoom, as am I. We have Linda Lowry, board member, Jim Stauffer, Greg Deck, Aaron Smith, also all board members tonight. Representing the city, we have Steve Bachmiller, our zoning administrator, and Debbie Calhoun, our zoning coordinator.
Mr. Chairman, for
Yes.
the initial case, we would like to enter the appearance of the city attorney representing the city in the pending matter that was continued from the last meeting.
Mhm.
And it's Jennifer Kiefer.
Jennifer Kiefer. Okay, good evening, Jennifer. That's fine. Tonight, we're starting with a holdover from last May, I think it was May 19th. We held off deliberating on that matter. We decided to take some additional testimony and documentary evidence for that case. We've received a couple things by email. There may be some other things that are presented tonight. I'm not sure. But I will go over our order of procedure just for everyone's understanding of how things will be handled tonight. The decisions in cases tonight are based on general and specific criteria as enumerated in the Land Management Code. This is an administrative proceeding, and as such, it will be conducted just as if it were a court of law, except that we will not follow as strictly the rules of evidence. Everyone who wishes to be heard on a particular matter will be heard. Each of the cases will be heard in the order filed with the board. Our procedure for tonight, we will first hear from the applicant, then all witnesses for, all witnesses in opposition, and then if necessary, final remarks from the applicant. We'll then take the case under advisement. We may deliberate tonight on these matters. If we reach a decision tonight, we'll have a written decision following our deliberations and decisions tonight. We'll have a written decision issued within 45 days. You're welcome to stay after your hearing and listen to our deliberation. It's not required. But during our deliberations, the only discussion we will have is limited to the board members and those who we may ask for clarification. You have a right to appeal within 30 days of the date of the written decision and order that is provided by the board. Any party who participated in the hearing or any others who have proper standing and are aggrieved by the decision may appeal to the Circuit Court for Washington County, Maryland. And again, that's 30 days after the date of the written decision and order, not the date of the hearing. We have two rules which we'll ask everybody to follow. The only remarks we will consider are those given from the witness chair under oath, and that we ask that anybody testifying confine their remarks to things that are pertinent to the matter under discussion. So we're going to start tonight with the continuation of case number Z 2021-02. This is a matter that's involving property located at 718 Forest Street in the residential medium density district. Application was made by Joan Lord, and I believe she's represented by counsel tonight still, as she was on May 19th. And tonight we're really limited just to hearing from both the applicant and the city as to any additional documentation that they have to either support the applicant's claim that this property is and has been used as a multi-unit dwelling, basically over under apartment type dwelling, or to dispute that this has been used in the recent past and currently as a over under multi-unit apartment building. So,
Mr. Chairman, two
yes.
points of order. One, you might want to just make sure we note for the record who are the participating members in this particular hearing, as it will change compared to the other three that are on the agenda tonight.
Right.
And also the second question is will both parties have the opportunity to do a summation at the end of closing of the additional material?
Well, I would like that just so that we all have it fresh in our minds as to what the positions are. So yes, I will allow both sides to give a summation. I'll start with, I think what I will do is I will start with the city to do that and give the applicant the final opportunity to sum up. That's typically how our cases go. The applicant gets the last chance to talk. So I'll stick to that, but I will give the city an opportunity to wrap up its evidence and its position on the case first. So, but I will hear tonight, we will start with the applicant, let them present their evidence and any other additional testimony to support their claim. Then we'll hear from the city. Again, both sides will be able to ask questions regarding the testimony and evidence that is presented tonight, just as we did on May 19th.
Mr. Chairman, just for the record, the three participating members in this particular hearing are yourself, Ms. Kelch, and Mr. Smith.
Yes, that's correct. So our deliberations and decision will be limited to just Ms. Kelch, Mr. Smith, and myself, since we were the only ones listening to the May 19th. We're the only ones who had the benefit of hearing all of the testimony. The others will just be in listen-only mode until we're done, and then we'll move on to our other three cases tonight. All right, so I will open the floor to the applicant and her representative. If you would once again just state your name and address for the record. Oh, let me swear you in first, though. Who's going to speak first?
For the record, my name is Daniel Mahone. I'm here on behalf of the applicant, Joan Lord.
If I may, just for the applicant and her counsel, I'll just remind you that you're still under oath. This is a continuation of the May 19th hearing, and anything you say will, you're saying under oath. So I'm not going to repeat the oath. I'll just remind you, you are under oath. So Mr. Mahone, if you want to go ahead and start.
Excuse me, Mr. Chairman.
Yes.
Mr. Lord was not at the last meeting. He needs to be sworn.
Oh, okay. Sorry, I didn't see him there. If you'll stand, Mr. Lord. Raise your right hand. Do you solemnly promise and declare under the penalties of perjury that the testimony you are about to give this board shall be the truth, the whole truth, and nothing but the truth?
I swear.
Okay. State your name and address for the record.
Christopher Lord, 718 Forest Street, Hagerstown, Maryland.
Thank you. Mr. Mahone, you have the floor.
Yeah, thank you. We're going to stand on our submission from last hearing.
Okay. Does Janice and Aaron, do you have any questions for Mr. Mahone or the applicant in that regard? You're muted, Janice.
I know one thing, we did ask for the insurance policy regarding the property. So that's the only comment I have, if that was something that is going to be entered this evening.
No,
Mr.
This is in
Mahone,
regard to the request for the insurance of Mr. Lord, you can speak to that in terms of how the house or the building is insured.
well, originally it was just insured as regular homeowners insurance, but as of Monday, it's been insured as a multi-unit property, which is, I believe, what was requested last time there was a hearing. I just couldn't get the proof of insurance from the State Farm website. I guess I gotta call the agent or something.
okay. Just to clarify, we didn't ask that it be insured that way. We were simply inquiring how it was insured.
Oh, well, it was
So-
just regular standard homeowners insurance. I think it was insured for like 268 or something.
Hmm.
For full replacement. I could get that info from the agent first thing in the morning.
We were, it was the first time that we had a private lender. Typically, when I buy a house, the mortgage company and the insurance company talk to each other, and the mortgage company knows what type of property it is and appraisal and things like that. This was a private lender, and none of that happened. So when he got insurance, he said, I'm living there, and they never asked how many units, and it just never, that's why last month I had no idea, because it was something I just didn't even think about until, I'd always been done with the mortgage company and the
Okay.
insurance company before. Because when in the past, when I had bought a multi-unit property, there was always a 1 to 4 unit rider on it, and the insurance company would see that. And when he spoke to the insurance company, they said, "Are you going to live there?" And he said, "Yes." And then that was never thought to do anything more.
Okay. All right. And this property was, just to refresh my memory, this property was bought and is in your name,
Yes.
not in a business. Okay. Just want to be sure.
I do not live there, but he does.
Yes. And you purchased this property how long ago, approximately?
3 years ago.
About 3 years. Okay. All right. Aaron, anything else?
No, I don't have anything.
Okay.
When
And
we purchased it, the upstairs was rented.
We kind of inherited
Yeah.
that. It was already sectioned off, that has separate kitchen, plumbing, all that.
That was one of our questions. We had requested the estimate. We were told at the last meeting that there were 3 estimates for plumbing and 3 estimates for electrical work, and we only got the 2 estimates from the electrical that was not who did the work. One of the questions, we So we were under the assumption that since the city did the work and the city put in 2 stoves and the city replumbed 2 bathrooms, and it was already separated into 2 units, that it was implied that there were 2 units.
Mr. Chairman, I have to object to that characterization. The city does not go around re-electrifying people's houses. There was a grant that was involved due to the very deteriorated nature and the safety hazard associated with the condition of the property back about 12 years ago or so. And there was a grant funding that the city allowed the property owner at the time, Mr. Haxton, to utilize. So we just wanted clear that the city did not go in and rewire this house. City does not do that.
Yeah, I'll take the testimony as Ms. Lord has presented it. It will evaluate our own take on it, but I do appreciate your position as well, Mr. Bachmiller, for the city. That's fine. And we'll hear from you and anybody else from the city as to other items. But I think this was touched on a little bit at the last and in May. Okay. All right. So if there's no other questions from Aaron, Janice, or myself, we will then ask for the city to present its testimony and any documentation that's.
Mr. Chairman, before we do that, we'd like the opportunity to ask the applicant a couple questions.
Sure.
Okay.
Yeah, I forgot I did allow that.
Mr. Lord, just so that we're clear, you said in your testimony that the property since Monday has been insured as a multifamily dwelling. Is that correct?
Right, correct.
So
Before it was
prior to
just
that,
standard
it was a single family
Right.
dwelling for the last several years with your ownership. in it. Okay. Second question I have is for Mrs. Lord. Mrs. Lord, you said that over time, when you buy houses, and then you went into commentary on that, and I noticed in your application, your email address is joanlord@horizonrealty.com. Could I ask what you do for a living, please?
I'm a realtor,
And how long have you been a realtor?
33 years.
And for those 33 years, you would characterize yourself as somebody who is well up on the necessities of that particular field of profession, being a real estate agent, dealing with people's houses, getting them the settlement, et cetera. So I would say that you would characterize yourself as somebody who knows pretty well your way around zoning laws and building codes to the degree that you help your clients.
No, I am not. That's not in my area of expertise. I'm also not a home inspector, nor am I an appraiser, no.
But you do know how to put people in contact with people who can get answers to those kind of questions for your clients, correct?
Right.
Thank you. I think we're good, Mr. Chairman.
Okay.
Thank you.
Okay. All right. So I'll open it up to the city then. Who's going to be testifying?
Mr. Chairman, I am going to just refer to the record
Okay.
that was already been submitted by the date that the board set for the submission of additional materials. It was sent out to everyone, sent out to the applicant as well. We were asked for materials associated with the building permit history, which were provided. We also have hard copies, additional hard copies here for anybody present who would like copies.
Okay.
This was as a result of the rather detailed conversation that was entered into involving Mr. Falk, Ms. Kyler, the applicants and the board regarding the permit history of the building and whether or not there were certain finalized permits on the property, various stickers and such. And the information was sufficiently vague, I guess we would say at that time, that you all requested additional information. We did submit that by the deadline for the record. So we just wanted to enter that officially into the record that it was received.
Yes, I will just reference that we did receive some items, including notification of required permits, building permit dated August 21st, 2018, with an inspection report attached to that. There was another permit date also dated August 21st, 2018, for residential alteration. I guess there's one looks like it's to do some framing work. And then another one that, yeah, I guess it's all for framing work. There was a handwritten drawing showing where the improvements were going to be made. There was a plumbing permit dated July 26, 2018. And then we also received a printout. It looks like it's from the city's own internal database, a screenshot showing, it's for trash services, I believe, trash billing and services. So we did receive those items. And if you will talk about them, we'll go ahead, and if there's no objections, we'll add those into the record as well, to the extent that they I should say that they refer to matters that we have discussed or that were raised during the May 19th portion of this hearing. I will remind Mr. Bachmiller and anybody else who was at the hearing that testified on behalf of the city, you're still under oath. Anybody who's going to testify that didn't testify at the May 19th hearing on behalf of the city, I will need to swear you in.
Mr. Chairman, we just want to enter a few points into the record that this material was submitted at the direction and request of the board for additional information based on the testimony provided by the applicants about certain permit activities.
Correct.
In this hearing, they have not followed up with any additional material, commentary. Their counsel has said that they are resting on the record they provided at the previous meeting. We want to point out that permits for utilities, electrical permits, plumbing permits, et cetera, those do not get reviewed by the zoning administrator, nor do they connotate or convey any sort of zoning approval. Those types of permits, I can be corrected by Mr. Falk or Mr. Moen, who are here from that department. But in summary, basically, all they really do is make sure that the contractor who's doing the work is sufficiently qualified to do the work. As zoning administrator, I do not review hardly any. I'm not going to say I never review a utility permit, but it's very rare. So they go through that process. I want to make sure that we are all clear that by having this material into the record, utility permits for plumbing and electric do not convey any sort of approval from my office or my chair for compliance with the zoning ordinance.
I think that's understood by the board.
Okay.
I had sent you.
And Mr. Chairman, I just want to point out for the record that the part of the material that we presented showed that the property has historically been charged one residential trash service. There's no record of it having been assigned two trash services. It also has one water and one sewer unit bill. It's assessed as a one unit property, and up until Monday, it was insured by the homeowner as a single family dwelling.
Noted.
And I'm going to reserve, we have certain summaries again that we will enter into our summation that recap some things, but there will not be additional material or additional new material, I should say.
All right. Okay. So anything else from the city before we move to sum up?
Stand by, please. No, sir, I think we're good.
Okay. Mr. Mahone, do you have any questions for the city regarding what?
No, sir.
Okay, thank you. All right. I will give the opportunity then to the city to sum up first, and then we'll go to the applicant.
Thank you, Mr. Chairman. I'll be as brief as possible. What we're here is an appeal to a zoning violation notice for the presence of a two-family dwelling where one is not permitted by the zoning ordinance. As a result of that violation notice, the applicant has raised the possibility of non-conforming use as a defense to protect themselves against the violation notice. This is perfectly legitimate within the zoning ordinance. Citing nonconformity is a legitimate defense to a violation notice. However, burden of proving a nonconforming use is upon the party asserting the claim, and that's the applicant in this case. The aim of zoning is to reduce as speedily as possible nonconformance to conforming with the ordinance. That's per County Commissioners of Carroll County versus Bueller, 78 Maryland, 140 in 1989. Also, it should be noted that nonconforming uses pose a formidable threat to the success of zoning. They limit the effectiveness of land controls, contribute to urban blight, and peril the success of the community plan, and injure property values. The purpose of such restrictions as prohibiting the right to change, expand, alter, repair, restore, or recommence after abandonment is to achieve the ultimate elimination of nonconforming uses through economic attrition and physical obsolescence. And this is from a case, County Council of Prince George's County v. E.L. Gardner Incorporated, a case from 1982. The law disfavors nonconforming uses and places the burden of establishment entirely on the applicant. So it's up to the applicant to demonstrate this is a nonconforming use, cite a date by which it became nonconforming, and demonstrate that it hasn't been abandoned for that period of 2 years or more. That's cited in our ordinance that allows windows as properties may sit vacant shortly or go through repairs. That date varies from jurisdiction to jurisdiction. I've seen it anywhere from 6 months to 3 years. Hagerstown's, our zoning ordinance is a period of 2 years or more, and it is lost. Nonconforming uses are detrimental to the community. They lower property values. They increase the density of the neighborhood. They contribute to blight and an inability to enjoy one's property. But especially in this instance, they are detrimental to the health and safety of the residents. As recently as December 2020, the tenant contacted the city and reported subpar living conditions, lack of adequate heat, and an internal staircase between the units. The applicant must show that the nonconforming use was in existence prior to March 7, 1977, and that said use has not ceased for a period of 2 years or more. That is what we are here tonight for you all to make a determination on. It really boils down to that one sentence. Is it a nonconforming use from a specific date? And anything prior to March 7, 1977 is not conforming. It's written into our ordinance, even though we had zoning prior to that. And then also, once that is possibly established, to show, and again, the burden is on them, that it has not been a second separate dwelling, that it has been two separate dwelling units for a period without a break of a period of 2 years or more. And it should also be noted that in the conversations that have been had with the last meeting and with this meeting, not necessarily with this meeting, but definitely with the last, the idea of renting rooms versus a dwelling unit have been somewhat used interchangeably. We want the board to understand that these are two separate concepts and definitions within ordinances. Just because somebody may have rented rooms at some point does not give them the legal authority to assume that that is a full, separate, distinct dwelling unit at some later date. We have two angles. So yeah, that's our two-part analysis that the board needs to define in order to vacate the violation notice. We want to point out that Calvin Haxton, the brother of the prior owner, said that his brother moved to Hagerstown and rented a room, not an apartment or a separate unit. Mr. Haxton in his material speaks of renting spare bedrooms in the house, but not an apartment or unit. The electrical estimates that we provided from the record from when they obtained the grant, Mr. Haxton obtained the grant to rewire the house, the electrical estimates, which were pretty detailed by the two electrical companies providing those estimates, make no mention of the second floor kitchen in either one of their estimates. Inspector Kyler testified to seeing some pieces of a kitchen up there, but again, this is all very vague. And also, illegal and casual use of a property is not in itself a defensible defense in non-conforming use. The legal use has to be a legal use in effect at the time that it allegedly became non-conforming. Second angle on this is that Mr. Haxton speaks of there being periods of time where he did not want to rent the house or parts of the house, whether they be apartments, whether they be rooms, etc. Inspector Kyler It testified as being in the property during the period of 2008 and 2011, and testified that Mr. Haxton was the only resident at that time. Next, we also want to make our position in our summation that arguments about permits are red herring. Unless there was a zoning certificate issued, building permit specifically signed by my office, there is no zoning approval for this or any real or implied zoning approval. The use of talk of electrical and plumbing permits to justify or demonstrate the nonconformity have no relevance, particularly to zoning, because as zoning administrator, I never approved them. I never saw them. The applicant was told in 2018 by me that the upstairs could not be used or converted into a dwelling. Nevertheless, she proceeded to pursue major construction inside the structure without further trying to resolve the situation. The city caught her doing these renovations without required permits. She obtained the permits. Again, these are utility permits, not zoning permits, and they do not confer zoning approval. They only ensure that the contractor is qualified to do the proposed work. Whether or not the permits were closed out satisfactorily or unsatisfactorily has no bearing on the approval of the zoning of the property, which they did not obtain. But the city would point out that only one of the 3 permits has a final inspection. The other 2 are without evidence of completion. The burden is on the applicant to affirmatively prove the existence of the nonconforming use. Even taking the evidence in the light most favorable to the applicant, she has not met the burden. At best, she has shown that the previous property owner rented rooms in the house for unestablished periods of time during the course of its ownership. That is not sufficient to prove the existence of a nonconforming use. The tax collector assesses the property as 1 unit. The water department assesses the property as 1 unit. The sewer department assesses the property as 1 unit. The trash collection agency assesses the property as 1 unit. Up until Monday, the property was insured by the applicant as 1 unit. There's no testimony from neighbors that this property is known to be a 2-unit dwelling. There is no testimony from the applicant that the property is insured as a 2-unit dwelling. The applicant was notified early on in her ownership of this property that it was not zoned to be a 2-unit dwelling. She has, in contradiction to that notification, taken upon herself to continue to pursue treating the structure as a 2-unit dwelling, and has done so at her own peril. Her actions cannot convert the structure into a non-conforming use. The property is not a 2-unit dwelling, and so applicant has not met the first prong of the requirement of the board and should deny her request. But even if the board finds that this structure is a 2-unit dwelling, the applicant has not met the second prong of her requirement. She cannot show that the property has been continuously operating as a 2-unit dwelling without interruption since March 7th, 1977, and all of these actions were taken by a professional in the real estate field with 30 years of experience. Thank you.
I did send a picture of the permit approval stickers. Different.
Yeah.
About the closing. His closing.
That, we're going to retain our position from the last hearing.
Yeah,
We don't have anything else to add.
Yeah, I mean, I just live there and there's somebody else that
right.
we,
And like you had indicated before, the rooms and units were interchangeable. When Walter rented the upstairs, maybe he rented individual rooms, but they did not have access to the first floor. So that's, if you have an apartment and you rent an apartment and you rent the other rooms, when he rented rooms upstairs, it was still, they had their own bathroom, their own kitchen, their own rooms. They did not come into this place at all. It's, yeah, so that's, yeah. So, yeah.
And we thank the board for listening.
yep, and thanks again for reconvening.
Thank you. If you have any questions.
Okay. All right, so we've heard summations from both sides. And we will now close this testimony portion of the hearing. And we'll move into our, we'll move into the next. We don't know, do we normally do our, I'm forgetting. Do we normally deliberate or we deliberate at the end?
You normally deliberate at the end.
At the end, that's what I thought. You know, the county does it differently. Well, they do it after every hearing. All right, so we will close this hearing and we will take it under advisement and we will come back to it after we've heard the other three cases and determine whether we can reach a decision on it tonight. I think we probably can, but we'll see. All right, thank you to the applicant, and we'll now switch into our next hearing. Of course, you're welcome to stay and listen, or you can find out tomorrow by calling into the office what our decision is. It's up to you. Okay, because we're going to be here for a while. All right, our next item on the agenda is case Z 2021-05. Mr. Bachmiller, you're no longer a witness. You're now the zoning administrator. So if you'll give us a summary of this particular case.
Certainly. And those representing Rhode Island Avenue, if you'd like to come up and have a seat. And just so everybody is aware, what you just saw was the extension of an appeal of a violation notice. Your all situation is a lot different. So if you were seeing what was going on here and start to freak out a little bit, don't. So, totally different legal proceeding. Okay. Give me 1 second while I get to the staff report. Okay, this is case Z. Oh, and for the record, Mr. Chairman, you
Yes.
have all 5 of your regular members present in this hearing, so they'll be the ones hearing this case.
Correct. Thank you for reminding.
You did. Yeah. So, okay, this is case Z 2021-05. The applicant is Darren Eby and Complete Builders. The property is located in the Armad zoning district. Property is located at 509 Rhode Island Avenue. The request is to construct a roof over an existing front porch that is 14.75 feet from the front property line. The application is being made for the reasons that under Article 4, Section D5A, the minimum front setback is 25 feet in the Armad zoning district, and Article 4, Section D5D, covered front porches may extend up to 30% into the required setback, or reducing that down to 17.5 feet from the right-of-way. So basically, they're asking for about 2.5 feet of additional distance into the front setback. The deadline for a written decision is July 31. This is an application for a variance. You have the 6 criteria under which you would review any variance that comes in front of you. Those are outlined in items 1 through 6, bottom part of page 1, top part of page 2 of the staff report. We have not received any comments from any other agencies, and staff has no additional comments.
Thank you, Mr. Bachmiller. Okay, all those parties who will be testifying on behalf of the applicant, if you will stand and raise your right hand. Do each of you solemnly promise and declare under the penalties of perjury that the testimony you are about to give this board shall be the truth, the whole truth, and nothing but the truth? And if you can say it loud enough for me to hear it.
I affirm, yeah.
Okay, great. Thank you. All right. If you have a seat, and then if whoever's going to testify first, if you give me your full name and your address.
Yes, hello. My name is Darren Eby, and I am the applicant on behalf of Gary here. I am with Complete Builders, and he has hired me to build a structure over his front porch, a roof for the existing concrete slab with a foundation that was put in previous to this. And when I applied for the permit, we realized that we was going to need to get some a variance for that. And there's several other, I actually went around and measured a few other covered porches on that street and the next street over. And I believe we have 24 foot 9 inches to the vertical face of the curb. Then from what I understand from Mr. Bachmiller is we need the property line is 10 foot back from that. So with that 30% infringement percentage there, brings us to needing 17'5". So I actually went around and measured several of the other ones, and I have at least 5 other ones that are closer to the vertical face of the curb than what ours would be. So there's several in the neighborhood that's like that. That's actually closer than what we're asking for.
All right. So explain to us what is unique about this property.
Well, obviously it was built, I'm not sure when the house was built, but it was built close enough to the setback where we couldn't put a front porch on there. And so now's the time that we're putting the front porch on, so we just need to get a variance on that.
Okay. And but there are other homes in the area that have the same situation, correct? You measure some.
Correct. There is one on Rhode Island Avenue and then 4 of them over there on Indiana Avenue.
Okay. And the existing porch is already encroaching over the current setback requirement. Is that correct?
I don't honestly know. I guess whenever they apply for the permit, I guess that there's a difference between a covered front porch and an uncovered front porch as far as what the setbacks need to be.
Maybe I'll ask the question a little differently. Is the covering over the porch essentially going to be limited to the dimensions of the porch?
Yes, that is correct.
The current dimensions. So if you build the covered portion over the porch, it's going to be encroaching over the setback line, and it's directly vertically above the existing porch.
Yes.
So if that's the case, then the porch is constructed. It may not violate, but the concrete porch extends over the setback line for the covered porch.
Yes, I didn't know it, but apparently there's 2 different things because they left them put the porch in last year or so.
Okay. Yeah.
And now whenever we go to cover it, there's an issue.
Okay.
Mr. Chairman, staff has some information may be helpful to the applicants in this case. I'll put
Sure.
that on the record if you want to hear it after they're done making their presentation.
Okay. Yeah, I'll come back to you. Thanks, Steve. All right. Okay. So, you're not going to extend it appreciably any further in front of the porch. Okay. Let's see. And then we have other properties in this district that have similar use. You've tested, and the house was constructed before the current owner purchased the property, correct?
He's saying, did you build the house? I already built. I bought 35 years ago, and it's built, I believe, in the late 60s. Yes, it was built previous to him.
And that he purchased it, and it was constructed the way it is, except for the porch.
That's correct.
Okay. All right. All right. Okay. All right. Anything else to add on this? Any questions from the board members?
I have a question. The porch you say was added about 2 years ago?
I personally didn't do it. He wants to know how long the porch was, how long the porch was there.
The slab was just put in within the last year. We got a permit from the city of Hagerstown, and it was approved, inspected and approved by the city of Hagerstown.
That was my question. Actually, was there a permit issued for the?
Yes, it was. And it was approved, inspected by the city inspector.
So was there also an approved variance at that time?
No, there was none required. We applied for the permit was issued to us, and we had a contractor build it. And the city, of course, had their inspectors come out and inspected it and approved it.
Thank you.
I would also like to mention something too. that we were talking about other dwellings with the setbacks. And I rode in the vicinity, in the whole area west end of Hagerstown. And I can get down Salem Avenue, and I know some of the stuff is old, but Dick's Market, for example, they have a roof built out, way out, it's halfway out into the sidewalk. It's 2 blocks, they're over the first block. And how did they get that without a variance? I don't understand. And there are other buildings also housing all the way up and down Salem Avenue
Well,
and side streets that are all much closer than what we're asking for.
and for the record, sir, would you state your name and address?
I'm Gary Steer. I live at 509 Rhode Island Avenue, Hagerstown, and I'm in the dwelling.
Thank you. Okay, any other questions from the board members? Okay, Steve, if you had something that you wanted to point out?
Yeah, I don't really think this is testimony. I'm just kind of clarifying the record. What we have out there, I noticed there's no photographs in the file that I can see. When we say porch, what we actually have out there is a ground level pad. You literally just walk onto it. Technically, that didn't even need a building permit, but apparently a couple of years ago, the applicant was inclined to want to put a roof over it at this point. When you do that, it needs a footer. So that's what kicked in the need for a building permit. If they didn't want to think about maybe putting a roof over it down the road, they may not, they would probably, for just pouring a pad, they wouldn't even needed a permit back at that point. When the building permit came through my office, there was no mention on it of a roof. So I think there might, I'm not going to say the city made any mistakes, but I think there was some miscommunication in this situation. That when the building permit was reviewed 2 years ago for this footer, essentially for the porch, the application could have been, the package could have been a bit more complete, and it was processed as it was, and it was approved as it was, based on it essentially being a ground level slab.
Right, okay. Okay, anything else from the applicant?
And I have to ask one question. You said we were like 14 and a half feet. We measured from the edge of the porch to the sidewalk, not to the boundary, to the sidewalk. And we come up with 18 feet 6 inches. And you come up with a different figure, but then you subtracted 3 feet, say right away. But that still knocked it back further.
It helped
than
you.
what it was.
It helped you.
You think it did? I thought it stopped.
It reduced the amount of incursion into the setback.
Right.
And just so everyone's clear, based on our analysis, short of getting a surveyor out there and getting it surveyed down to
The inch.
the inch, by our best estimates, based on the right-of-way maps, the property front corners are pinned. Calculating it out, it's my understanding as zoning administrator, and I think I've got a pretty good fix on it, that where they're looking to put this porch roof will extend into the front yard beyond that 30% allowable incursion by 2 feet 9 inches. We're talking a distance of about this far that this porch roof will stick beyond what the code would otherwise require.
So what you're saying is you permitted me to build a porch or a slab, not a patio, but a porch, knowing that we said at the time that we were going to put a roof over it,
I did not know that.
but we did, and you said, you mentioned it earlier.
I'm trying to help you here.
I know you did, but it's still with me, it was confusing too, because when you set it up, talking about for me.
Right.
I'm getting a little older, I don't understand, and I don't hear as well.
Yeah.
But, and I appreciate everything that's done.
When we signed off on that permit for the slab, there was no need for a permit. It was just going to be a ground level slab. You can pave your yard.
That's what you thought, and I
Right.
thought the opposite.
What triggered the permit was that they apparently at that point desired to later put a roof over it. So they applied for the permit, but that information did not get back to us in zoning. And we looked at it and said, okay, there was no mention of a roof, so we just approved it. So
Right.
again, I'm not saying the city made a mistake here, but I'm just saying that communication could have been better.
Yeah, and it sounds to me like it's kind of a, it's no harm, no foul. I mean, it could have been handled a different way. if there was more information from either side, questions asked or questions answered, but it wasn't. So it's not, I don't look at it as a big deal. The fact is the porch was constructed. There was an expectation that there was not going to be, on the city's part, there was no information presented that there was going to be a porch, a roof over top. So it was allowed without having to have any kind of variance. Now that the porch is being built with a roof, or the roof is being built over top of the porch, now a variance is needed. So,
Can I say
It's-
something real
yeah,
quick?
go ahead.
So that actually, there's a footer underneath of that porch around the perimeter. That's why we can't really move. We can't really shorten the porch up because we'd have to rip out the concrete
Sure.
and or drill holes down through the middle of the porch for footers.
That's good additional information. Yeah.
Yeah, I mean, I think it's always a good idea to have extra underneath a concrete slab, even if you're not going to build something on top of it. Because with
I
the,
guess actually, I wasn't really involved with the porch, but had Gary known, he may have shortened the porch up a little bit for future time, so that the footer would be underneath of the perimeter of the porch, but.
Yeah.
I guess hindsight's 20/20 here.
Right. That's okay. I mean, we're not worried about the construction. We're worried about making sure that if necessary, that a proper variance is granted if all the criteria are met. So, okay. So I think we've heard from the applicant. The board has had an opportunity to ask questions. Is there anybody else who's going to testify in favor of the application? Okay, hearing none. Anybody who's testifying in opposition to the application? None? Okay. Any final remarks from the applicant?
Yeah.
Okay. All right. So we will close the testimony at this time. We'll take the matter under advisement and we will come back to deliberate after we've heard the other cases in order. Okay. Thank you very much.
Thank you.
Okay. Our next case is case Z2021-06. And Mr. Bachmiller, if you can give us a summary of this.
Yes, this is case Z 2021-06. The applicants are William and Shelley McIntyre. Property is located in the Armad zoning district. Property is located at 2 Mealy Parkway. This is the corner of Potomac Avenue and Mealy Parkway. Basically right across Mealy Parkway from the Korean War Memorial. The request is a variance to construct a shed/addition 20 feet from the front property line along Potomac Avenue. This application is being made for the reason that under Article 4, Section D5A, the minimum front setback is 25 feet in the Armad zoning district. Deadline for written decision is July 31. This is an application for a variance. As in the previous case, you have 6 criteria which you would need to review the application against to see that they meet those criteria in order for the variance to be granted. Staff adds to the unique condition of the property. We've been out and looked at the situation. The house was built 1 foot into the setback based on the original plat. So there are peculiarities on this property. And that when the plat was recorded, I want to say 30 years ago or so, for some reason it was recorded with, I believe, a normal side yard setback, not a side street setback. So as a result, the existing house is 24 feet. And when it was built that way 30 years ago, 24 feet from the right of way of Potomac Avenue, which is 1 foot inside of the current setback requirement. The applicants are looking to build a small shed on the side of the house. It's about 4 feet deep. So it takes it from 21 down to about 20 feet from the right of way of Potomac Avenue. The applicants are prepared to show that due to unique site constraints, this is the only place on the property to place a shed. And then we had no additional comments on the other 5 criteria, and we received no comments from the review agency.
Okay, thank you. All right. If the party is present who's going to be testifying, will stand. Raise your right hand. Do you solemnly promise and declare under the penalties of perjury the testimony you are about to give this board shall be the truth, the whole truth, and nothing but the truth? Okay, great. Need to hear it. Thank you. State your name and address, please.
William McIntyre, 2 Mealy Parkway.
All right. I'm pulling up your property on Google Maps just so I can get an idea. I grew up right across the street. And I'm trying to get the lay here of where this, okay, I see now. Yeah, you're right on the corner there. I see you've got some, if this picture is still correct, you have quite a large tree break or tree line along Potomac.
No, it is gone now.
Oh, it's
That was-
gone.
All that was taken down because it was just, almost blighted.
Okay.
The power line. over the
Okay.
line.
So that area is cleared enough now to be able to put a shed.
Yeah, since then, there was a permanent fence put up and landscaping along Potomac. So any shed couldn't go out towards that way. The other side of the house has Bilco doors and a fireplace chimney. So, and plus it's only about 8 to 10 feet away from the fence line to the neighbor's house. And most of the backyard is taken up by a permanent deck as well. So that was pretty much the only location we could, think of. And we tried to keep the square footage as small as possible for what I wanted to use it for, and keep it up against the house so it doesn't obstruct any view into the backyard.
Okay. Approximately how tall is the shed?
It's probably, I'm going to say it's probably about 9 feet tall,
Okay.
4 by 10.
And the fencing that you've installed along Potomac, what type of fencing is it?
Wooden fence.
Is it like wood pickets or?
Yes.
Okay, so you can see through it.
Yeah, whatever the permit states. I don't, there's, the gaps between each picket are up to
Okay.
code. So
Okay, it's not just a continuous wall all the way across.
No.
Okay, and approximately how high is the fence?
3 feet.
3 feet. Okay. Let's see. And so this shed is going, if I'm looking at your package correctly, this shed is going to sit. Let's see. It's going to sit how close to the house?
It's right against the house. It's not
Right.
attached to the house, but it's built, it's
Okay.
right up against the house. Yeah.
Okay. And so even being almost right up against the house, it's still going to extend into your side setback. Okay. All right. And let's see. When did you buy the house?
2001.
2001. In the shed, what are the dimensions? The area dimensions of the shed?
I'm sorry, what?
The aerial dimensions of the shed?
4 by 10.
4 by 10.
Yes.
And so the 4, is it the 10 that's going away from the house or the 4 that's going away?
No,
From
four.
the 4. Okay, so the smaller area is going away from the house.
And
Okay,
and we placed it, there's two windows for the basement as well.
Mhm.
So on that side of the house, so we, keep it in between those.
between the windows. Okay. I do notice on a house location survey that you included with your package, that there was at one time a shed in the back of the property behind your house.
Yeah, if you say you grew up there, you saw, I guess you had witnessed all those trees there. They grew into the shed,
Yeah.
sort of rotted out. That was taken out when we re-landscaped everything. If that shed was still there today,
Mhm.
it would be blocking the view coming into the backyard.
Okay. And you said you've got landscaping back there now, so you're not able to put a shed back there.
Correct.
The whole fence line has landscaping, trees as well.
Okay. So this is the first shed that you've installed, or if it's approved, yeah. Okay. And it has not been installed yet, right?
No, it is.
It is installed.
Yeah, we had a stop work order and it's been stopped work since.
Okay. Okay.
So, to explain that, basically, we were under the threshold of the 900 square feet. So, that's why.
Okay. All right. Is this something that, how did you come to find out that it needed a variance?
Through my wife's a city councilwoman, so she had somebody had mentioned it to her in City Hall here.
Okay. Okay. You didn't receive a notice of violation or anything like that?
No, it was just call and then to come out and inspect the shed, make sure there wasn't any electric or it was attached to the house, and then it was brought to our attention about the variance.
Okay. All right. And this property is somewhat unique in that we've got you are a corner lot. I mean, not that there aren't other corner lots in the area, but this is, one of those that that is kind of subject to different types of setbacks than other properties that
and
aren't corner lots.
So on that house location survey that's in our packet,
Mhm.
it shows the deck on the back of the house. The deck's much larger now. We had, another permitted deck put on to that.
Mhm.
So it has taken up a good portion of our back, the backyard. So
Okay. What was that? Did you get a variance for that?
excuse me.
Did you get a variance for that?
Yes,
Okay.
actually had to once we submitted everything, we actually had to take 1.5 feet off the deck closer to the house.
Okay.
So yeah.
Okay. Yeah, because I see that the original deck was right up against the setback line, looks like.
Right.
Okay, good. All right, good. Okay. Any other question? Anything else you want to tell us about this?
No, I think that's good.
Okay. What do you plan to store in the shed?
Lawnmowers, weed whacker.
Okay, garden.
Yeah, that's why we just tried to keep it. I'm kind of tired of them sitting under the deck. So we try to keep, like I said, we try to keep it as small as possible, just enough for me to keep that stuff out of the weather.
Okay, good. And is it being constructed or is it a pre-built? Was it constructed or was it a pre-built and that's dropped onto a?
No,
It was constructed. Okay. All right. Any other questions from the board? Okay. All right. So I'll ask then, is there any other witnesses in favor of the application present tonight? Any witnesses that are in opposition to the application? Okay. One other question popped into my mind. Mr. McIntyre, have you talked to any of your neighbors about putting in, and do you have any sense of how they feel about having the shed there?
Nobody has said anything negative. Most of the time we get compliments on the landscaping and the shed as well. I've never heard anybody say anything negative. No.
Okay, great. All right. And any final remarks from you then?
No, sir.
Okay. All right. We will close the testimony now and we will take this under advisement and we will revisit this in the order once we're done with the next case. All right. Thank you. All right. Jumping back to my agenda. The final case tonight is Z 2021-07. And Mr. Bachmiller, if you give us a summary.
Okay, this is Z 2021-07. This is the applicant is Bruce Poole and Harry Jones, JP Investments LLC. Property is located in the Armad zoning district. Property is located at 801 Security Road. This is for a variance to construct a single-family residence 8 feet from the front property line. This is actually a side yard along Division Avenue. Property is located at the intersection of Security and Division. The front architectural front of the house, front setback is on Security. But we treat all the street frontages as fronts. And as a result, the side street along Division Avenue is a front setback, and they're seeking a reduction in the side street front setback. And the application is being made for the reason that under Article 4, Section B5A, the minimum front setback is 25 feet in the RMOD zoning district, and they're asking a reduction to 8 feet. Deadline for written decision is July 31. Again, like you had in the 2 previous cases, you have 6 criteria by which you review variances, and we have received no comments from any of the review agencies.
All right, thank you very much. Okay, all those who are going to testify on behalf of the application, I'll ask you to stand, raise your right hand. Do you solemnly promise and declare under the penalties of perjury that the testimony you're about to give this board shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat and state your name and address for the record, please.
Okay, Ronnie Bidle. I'm a survey manager for Triad Engineering here in Hagerstown, 1075B Sherman Avenue.
Could you repeat your last name again?
Bidle.
Bidle. Okay. Mr. Bidle, go ahead and tell us about this application.
Okay, yeah, I was chosen by Mr. Jeff Piper to provide survey services for this property, which is owned by JP Investments, which is Bruce Poole and Harry Jones, our partners. And they actually bought 3 lots, this being lot 172. They also bought lot 173 and 174. So there's 3 contiguous lots there on the corner of Security. And when they purchased the property, it was based on the legal description, which stated that these were being lots 172, 173, 174 on the plat of Taylor's addition to Hagerstown. And I didn't know if you all have the handouts. I included a copy of that plat as an exhibit.
Yes, we do.
Okay.
The members of the board have copies of these plats that are part of the package.
Okay, and it is a pretty rough copy, being that these lots were originally subdivided in 1913.
Yeah.
And of course, the owners bought these lots based on, how they were depicted on this plat. And I outlined the lot itself, the subject lot 172 in green, and then highlighted the setbacks as shown on the plat in red. And if you can probably tell, it's really hard to decipher, but we did find a few places that the front setback shown here is 30 feet. And the sides look to be about 8 feet. So to me, that it pretty much shows the intent that the lots were to front Security Avenue or Security Road, I'm sorry. And of course, that's what the owners intended to do with all 3 of these lots. So based on these are also 50-foot wide lots. I think every lot in the subdivision is the same width. So they basically came up with a house plan, that will fit on a 50-foot lot with these setbacks. And it wasn't until Mr. Piper contacted the city, about pulling a building permit for lot 172, that he was informed this is the double front corner lot. So you had to abide by, the 25-foot front on Security as well as Division. So at that point is when we realized we needed a variance. And to explain the unique conditions of this property, I think the most unique part that these are undeveloped lots, that were established in 1913. And I think if you look throughout this entire neighborhood, I think I counted maybe 8 lots, throughout probably a couple hundred lots that are not developed. And the fact that they were, established so far ago, of course, there was not a zoning ordinance in effect. And now that they're being developed, of course, they have to abide by the current zoning ordinance. But if you take those setbacks that are required today, it actually leaves only an 18-foot wide building envelope on that corner lot, which is more like a townhome
Right.
width versus, the width they would like to build is about 34, 35-foot wide house, which seems very typical for this neighborhood. There's another exhibit there. It's an aerial view that I went down Division Avenue and I labeled every setback, I guess it would be to an existing building, along Division Avenue. And on our side of the street, there happens to be 1, 2, 3, 4 structures, 4 existing buildings. The one, of course, being Starland. But 3 out of 4 of those existing buildings are closer than 8 feet, which is the variance that the owners are requesting. And then the other side, there's a few more, and they vary. The closest is roughly 2 feet up to, it gets up to 20 feet or better. But it seems like, the existing structures out there are like closer than a 20-foot 5-front setback. And therefore, once they construct this building, on the corner, I think it'll look a lot more uniform with the existing building, as well as uniform along security. We actually did check, we checked a few of the houses for Mr. Piper before we started staking out the first house that's under construction. Because he said, we want them to line up. So we took the time to measure several of the houses along security to make sure they all lined up. That, they're trying to conform to the neighborhood, blend into the neighborhood type of deal, which is why we need area.
Okay. All right. Let's see. On the drawing that was it's like a surveyed drawing that was done. It's showing that there's an alley at one end of this lot, a 12-foot alley. Is that the lane that runs along Starland?
That is correct. I don't think it's an improved alley.
Yeah, it looks more just like it comes off of Division. It looks like there's a little apron there.
Yeah.
But it's hard to see on Google Maps because there's a big shadow from the roller rink itself. I can't see what it goes to. It may be paved, but then I can see several lots past the roller rink where it just looks like a grass path almost. So I'm just trying to orient myself on the map to your drawing.
Sure. Yeah, and I think that is the case. There's an apron, but I think it only goes so far.
Yeah.
Right.
Okay. And it does look like there is quite a narrowing of this lot as you go further back, or as you approach security. You go along Division, as you go closer to security, it starts to narrow. It looks like it's 56 at the back and 40 and almost exactly 50 at the front. So that, of course, squeezes that setback line even closer. Okay. All right, so we're going to have an equal 8-foot distance on either side of this dwelling. Is that correct?
That's correct.
Okay, so keeping it right centered in the middle. All right.
Right. And that will match the next 2 lots as well.
Okay. There's nothing on those at this time, right?
Actually, 173, lot 173 is under construction at this time. 174 is not yet.
Okay. And 173 doesn't need this because it's not a 2-road lot, correct?
Exactly.
Okay.
Yep.
All right, there we go.
Yep.
Okay. Let's see. Anything else? Any questions from the board?
Yes, Mr. Chairman, this current lot 172 is also under construction. Correct?
Not at
Not-
this
not at this
time.
time?
There has been some, were they public improvements? I think maybe City Light, but not by the owners. They haven't, other than uncovering some utilities, they did search for, where the utilities are stubbed. But I think that's the extent of what they've done on 172 here.
Okay, fine, thank you.
Yeah.
They haven't put, do they have a grading permit yet?
Yeah.
Okay. All right.
Yeah, that was the point at when we realized they needed a variance.
Okay, good. All right. Any other questions? Okay. Anything else? Let's see. Any other witnesses who want to testify in favor of the application? And any witnesses in opposition? Okay, Mr. Vital, any final remarks?
I don't think so.
Okay, all right. We'll take this under advisement and we will deliberate in the order of the cases as they were presented to us. Thank you.
Thank you.
All right, so we will return. That ends our agenda for tonight. And so now we'll move to deliberations. We'll start with the hearing, the continuation of the May 19th hearing matter.
Mr. Chairman,
Yes.
you have applicants sitting in the audience. You might consider taking their cases first so they can leave the deliberations on the cases that the
Okay.
applicants are no longer
Okay.
here.
Okay, so the Mr. Mahone and his clients left?
Yes,
Okay,
I'll check the hallway, but I'm pretty sure they're gone.
okay.
Mr. McIntyre.
Yeah, so that, okay, we can do that. Then we can jump to the first one if they're not present. They won't miss out on anything.
Yeah, the only parties that we have here are Rhode Island Avenue and Security Road.
Okay, all right. So let's start then with, let's see, Rhode Island and security. So we'll start with Rhode Island. That was the first one. Then we'll go to security and then we'll jump back to the other two. All right, so Rhode Island, this is Z 2021-05. This is the request to construct a covered roof over an existing porch and need a approximately 3 feet, 2'9", 3 foot variance beyond the current, well, I guess you'd say that it's the porch encroaches, but that's not what we're here for. We're here for the roof. So instead of 25 feet, we're looking at a 14.75 feet distance from the house, or I'm sorry, distance to over the setback line. Okay, so our first criterion is the unique condition of the property. This particular property, unlike the other two, is not on a corner. So we're looking at just having to put the porch over the roof over the porch. We heard testimony that many other lots in the area, the homes are already, these were platted and many of the homes were built before the establishment of the setback lines as they exist today. and that many of them are, some of them may be further forward across the setback lines than what the applicant is asking for. We've heard testimony that this is only going to extend to cover the aerial dimensions of the porch. It's not going to encroach even further in any appreciable manner beyond the porch, edge of the porch from the house, and that it will likely be in some sort of aesthetic coherence with the property, the rest of the dwelling. So this appears to be because of the shallowness of the lots and the current placement of the home on this lot as well as other lots, that this is what happens. We're beyond the current zoning requirement for a 25-foot setback, and you know, there's a pad, a slab, if you will, and that they would like to cover it so that they can have probably shade for their front doorway and a nicer appearance to the entry to the home. It does appear that this is one of those homes that we would call sort of unique in the area, and that everybody's in violation with their homes already being over the setback line. So this is just asking for a little bit further out to cover this porch. Is it the minimum necessary to afford relief? Well, if you want to have a covered porch, you're not going to make it shorter. You're going to have it go over top to the edge of the slab. So I think this is the minimum necessary that's being requested. Our third criterion, compliance would preclude common use. We see that other applicants, or rather other properties in the area, do use their homes this way. They have front porches. Some of them have coverings over top of them, and some of them, I'm sure, are over the setback lines. Whether they obtained variances or they did not, it's somewhat typical in these types of neighborhoods. Criterion 4, no special privilege. As with other similarly placed dwellings in this neighborhood and within this particular district, the Armad district, if their homes are already built over the setback lines, anything they want to do, especially in the front yard, is already going to be encroaching. So they would need variances, and we would likely grant those variances if they met all the conditions. Let's see. Our fifth is a self-created hardship. The home was constructed in a way that pushed it either to or beyond the setback line already. So installing a porch had the effect of, being additionally over the line. I don't think that that's really self-created so much as it is just the nature of these types of dwellings in this particular neighborhood. Covering over the porch is already there, and the porch technically doesn't need a variance itself if they weren't going to put a roof over it. So putting this over top doesn't really affect the fact that we're over the line already. It doesn't make it any worse. And then, is it consistent with the intent of the ordinance? It will be in harmony with the rest of the article, and will not be injurious to the neighborhood or detrimental to the public welfare. I mean, other homes are similar situated, and many of them have these covered porches. So in my opinion, the criteria are all satisfied for construction of this covered porch as requested, to allow a variance from the setback from 25 feet to 14.75. Anybody else from the board have any questions, comments, or objections?
No objections.
Okay. All right. I will entertain a motion then.
Mr. Chairman, if we could have that with the usual condition of complying with the testimony.
Of course. Yeah.
Mr. Chairman, I'd like to make a motion that we accept the variance as stated.
All right. Okay, so motion has been made to accept the variance as requested. And as Mr. Bachmiller pointed out, we always require that it be constructed in conformance with the testimony that's been presented. Any changes would need to come back to this board if it was going to extend beyond the approved 14.75 setbacks. So do I have a second?
A second.
All right, Janice, you jumped. I think you were a split second ahead. Okay, so let's have a call out of our members that are here for voting. Janice, how do you vote?
Favorable.
All right, Greg,
Aye.
Jim,
Aye.
Greg.
Greg's not participating.
Oh, Greg's not. I'm sorry, Laura.
Aye.
And
I'm sorry, it's Aaron who's not participating. Greg's
Aaron's-
not on the board anymore.
Okay. All right. So we've got, did I catch everybody? Who did I leave out?
Thank you.
You.
And me. And I'm in favor as well. Okay, it's unanimous, 5-0.
I'm
All
zero.
right. I would suggest that the homeowner wait. You don't have to wait, but it's always good to wait until the decision is issued. If you do any work at this point, you do so at your own risk. Somebody may appeal this to the circuit court. There's nobody here in opposition today, so that's not likely, but it is always a possibility. But we'll try to get this out as fast as we can and no later than July 31st. Thank you. Okay, our second, let's see, we're going to jump down to the Security Road. That's case Z 2021-07. This was a request for a variance to construct a single-family residence. The current setback requirement is 25 feet. They're requesting a variance to 8 feet for this construction. We heard testimony that this is a uniquely shaped lot. It's situated at the corner of Security and Security Road and Division. I believe that's an avenue. Division Avenue, and that it therefore has a slightly different arrangement of the setbacks, in that they're both they front on two roads, and both those frontages require a front yard setback of 25 feet, which is not typical for properties that are not on the corners. This property has, we also were presented with evidence and testimony regarding the layout of the home on this lot, that it is going to, it's going to be fronting on Security Road, and therefore the 8 foot that they're looking for, the variance that they're looking for, will be on the Division Avenue side of the property. The home is being placed directly in the middle, so that we'll have two 8 foot distances, both if approved, the 8 foot from Division Avenue to the side of the house, and 8 foot from the side of the house to the adjoining lot 173, which the applicants also own, or the property owners also own. Given that they would be shrunk into an envelope of, the testimony was approximately 18 feet to build a home there, it would likely not be a very large single family dwelling. It would probably be a townhome, a very narrow townhome if it were to go there. And so I think this does have a unique condition, given the parameters in which this lot is situated and the narrowness of the lot forcing this request. Second criterion is it the minimum necessary to afford relief. If you want an aesthetic view of this home from Security Road, it's nice to put it in the middle. You don't want to bring it closer to the setback line on the other side. It would shrink that, would push that home. Looks like maybe about 4 feet. If it stayed within the setback line, it would be like really close to the side, to lot 173, if you moved it any further to that side. So centering it in the lot is the most aesthetically pleasing and logical way to position this home. So it does appear to be the minimum necessary to construct this home and have it be on the lot in a good way. Third criterion, compliance would preclude common use. Likewise, for any corner lots in this zoning district, they're going to be faced with the same type of setback situation on both of the roads that they front on. And if you build a single family home, you would likely be forced, unless your lot was a lot wider than 50 feet, you'd be forced to ask for a variance if you're going to center it in the middle of the lot. Is there any special privilege being granted for other similar situated properties and similar type homes? If they were to be constructed in this district, you would likely also need a variance. So it doesn't appear that any special privilege would be granted to allow this home to have this variance. Is it a self-created hardship? No, they did not plat the lot, and they purchased it as is with the setback lines as they exist due to the current ordinance. Is this consistent with the intent? Granting the will be in harmony with the general purpose and intent of the article, and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. We had testimony, we saw an aerial exhibit that showed that a lot of homes that are situated on corner lots come way closer to the roadway and are encroaching over the setback lines. And so this is not as bad as some, and it would still maintain harmony with the general nature of the welfare of the neighborhood rather. Any other comments or questions from the board? Okay, so I will entertain a motion then to approve or reject the application for the variance from 25 feet to 8 feet.
With the usual condition,
With the usual conditions.
if it's approved.
If approved, correct.
I'll make a motion to approve the variance based on the testimony and evidence provided.
Thank you, Jim. Do I have a second? Okay, Janice, I saw your mouth move.
A second. I second.
Okay. All right, I have a second. Okay. So let's go around the horn. Janice, you approve or reject?
Yes.
Okay. Jim,
Yeah, aye.
Laura,
Aye.
Aaron? Not voting. Greg?
Aye.
And I am an aye as well. So we've approved 5-0. Thank you. So Aaron is the alternate, correct?
Correct.
Okay, got it. That's why I keep making the mistake.
And Brian, what was the articulated justification criteria 6, just so I have that for the decision? I did.
Let's see, consistent with it. Oh, that there are other. So is it in harmony with the general purpose and intent of the article? I say yes, it is, because we want lots to be used to a reasonable purpose, and that it will not be injurious to the neighborhood or otherwise detrimental, because it's situated on a lot in the most aesthetic way. It is not encroaching over the setback line as much as some other corner lots in this neighborhood, and so I don't believe it's gonna cause an injury to the neighborhood or the public welfare.
Okay, thanks.
Okay. All right, so that one's approved 5-0. Okay, thank you very much. We'll move on to our other two, where our applicants are not present, and we'll start with what I believe will be the easier one to get through. And that one will be the Mealy Parkway request, Z 2021-06. And this one is a request to allow the placement of a shed, a 4x10 shed along the side of the home that is located there, a single family dwelling. And it is asking for a variance from a 25-foot side yard, but it's a front yard setback. It's on the side, but it's a front yard setback due to the fact that it's on a corner. And they're looking for a variance from, let's see, the variance is it 20 feet there? I think it's
Going from 25 down to 20.
25 down to 20. Okay, got it. Yeah, so they're looking for a 5-foot encroachment over the setback line. Okay, this one, similar to our property over on Security Road, is also a corner lot and has the same type of situation in that because it's on a corner lot, they are the two lots that or the two roads that it fronts on cause it to have a front yard setback. And as we discussed in the previous case, this does present some unique challenges for homeowners when they want to do anything on either side that fronts a road. And the applicant submitted some exhibits, including a house location survey showing the location where the property is actually situated on this property, and it's pretty much right in the center. And anything that they do on their side of their home is going to go over the setback line. I noticed from that house location survey that the Potomac Avenue setback line that the surveyor drew is only, looks like 10 feet. But as we know, the ordinance adjusts that to 25. So that pushes it right up to the side of the house almost. And so we're looking at trying to get something that is squeezed in there between the utility area and the side of the home. The homeowner testified that they are going to use the shed for typical storage of garden, mower, and other implements for landscaping, that they currently store them under their deck, which of course, you know, subjects the mower and those implements to some elements of the weather. And so it's natural for somebody to want to put them into a covered shed. And like was presented in the other case, this does create some unique situations for this particular property due to its being a corner lot and having some narrowness to it. It looks like this one is approximately 65 feet wide. So it's a little bit wider than the ones that we had over on Security. But nevertheless, it's putting a small shed like that only 4 feet off the house is still pushing it over the setback line. So that is somewhat unique. Is this the minimum necessary to afford relief? 4 feet wide is pretty narrow. So that does seem to be a reasonable request. It's not a double wide shed. It's just enough to get in their mower and other items. So it does appear to be the minimum necessary. Would compliance preclude common use? I'm sure that other lots in this neighborhood with similar corner configurations would have difficulty putting typical size sheds on the side of their homes that fronted on a public road as well. So this would preclude common use and deprive the applicant of uses commonly enjoyed by other similar properties. No special privilege, just as I just mentioned, due to the unique nature of this lot being on a corner and having the setback line then applied at 25 feet on both sides that front on the road. Anybody else coming to us would also seek a similar type of request, and if they met the criteria, we would likely grant them. So it's not a special privilege. Is it a self-created hardship? They did not plat this land. They bought it as is with the home already constructed. And so that limited where they could place their shed on the side of the house. Having the deck already constructed in the back, right up to the setback line, would have made it difficult, if not impossible, to put it in the back unless they also got a variance from us. So this is not really a self-created hardship. And is it consistent with the intent of the ordinance? It is in harmony with the general purpose and intent of this article, and we want property owners who find themselves on corner lots to be able to use their property in a reasonable way, typical as other home owners would use. And it will not be injurious to the neighborhood or otherwise detrimental to the public welfare. It's a small shed. It's right up against the house. And it's, somewhat normal to see a shed on a property like this. So I think that they satisfy all the criteria in my opinion. Anybody else have any comments, questions, issues?
Yeah, actually, I just wanted to bring something to the attention. To back up to number 5, self-created hardship. One of the things that we do need to take into account is this property had a lot of changes in the last few years that were permitted, including the replacement of the rear deck. The only reason why the shed cannot go back easily into the backyard where it was previously is the new deck that was permitted is much larger, which takes up the space. So that kind of does feel like it could be considered a self-created hardship. When you talk about the property itself, when the position was that they want to put it on the side because the backyard is no longer big enough.
Well, the previous deck was already on right up to the setback line. So that they couldn't have put it behind the deck without getting a variance anyhow. They would have needed a variance no matter what back there. If they had decided to put a shed back there. They said that they tore down the other shed because it had been, I guess, overgrown by the trees that used to be there and was no longer in good shape. So they tore that down and did normal landscaping.
Mr. Chairman, if I may, the original deck, there was 35 feet from the deck to the edge of the property line. There's an awful lot going on this property. I live by it. And yes, that deck now almost takes up the entire rear yard. Actually, I guess that's also somewhere front to home. So, it could be stated that it is somewhat of a self-created hardship.
Well, yeah, I hear what you're saying. I'm trying to read this in the context of this criteria. It says that they have they created or caused to be created a situation which would or has necessitated the issuance of a variance. They would have needed a variance even if they had left the deck where it is, if they had put the shed in the backyard, behind the house. They would have needed a variance because the setback line, if I'm reading this right, let me blow this up.
I guess my challenge is the original shed that was removed recently was in compliance because its position was further back, so it didn't have a setback issue. The removal of that, the extension of the deck, and then the desire to put a new shed in a different location, requiring it to be a variance. Does that have a play?
Actually, if this drawing is correct, where that shed was located is within 25 feet of the right of way of Potomac. And if they wanted to build a shed at that location now, they still need a variance.
They'd still need a variance. Yeah. So I don't think they have a situation where they had a place where they could put this shed and not be in violation.
The sidewall of the house is at 24 feet.
Yeah.
So if you go 1 foot to the right and draw a line parallel to the sidewall of the house,
Yeah.
that is the furthest forward that that shed would have to be, and that location that's shown on the drawing is about half into that.
Yeah.
Basically, it's straddled.
So the previous shed was also encroaching.
Yes.
Yeah. And so so they would, even if they had put it where the shed currently exists, it's over the lines. And I don't know if there's anywhere.
Was it the shed that was blocking the view, the previous one? It mentioned was blocking the view.
In the back, yeah. Yeah, because the trees were dead, or they said they were in really bad shape, so they just decided to take out all the trees on both sides. And that in the shed in the back had been overgrown. Some of the trees, I guess roots or whatever, had gotten in, and the shed just couldn't be. It wasn't sufficient for the purposes anymore, so they just took it down. But that where it was located was already over the Potomac Avenue setback. And Steve, do you know what the rear yard is? The rear yard setback 35 feet? as shown on,
35 feet for the principal structure, but there is a provision that allows decks to extend into that.
how about for placement of a shed?
For the replacement of the shed, required setback would be 5 feet off the rear property line. 4
5
feet
feet.
off the other side interior and 25 feet away from the Potomac.
Okay. Okay.
By the time you apply all those setbacks and then have the deck sit there, there's not a whole lot of that.
There's not a whole lot of room, yeah. Okay, so let me read this one more time. Okay, so. The creator caused to be created a situation which would or has necessitated the issuance of the variance.
Something to think about in your deliberations. You have multiple arguments that are made here. I guess the question becomes, do these ones that you point out void or veto the other unique characteristics that were cited by the applicant?
Mhm. Okay. Jim does raise a good point though, because it does appear that even, if that deck comes back out and if they tore down the old shed, is there a place that they could have relocated the shed prior to putting the deck in? I'm not sure. Jim and Greg, you said one of you has looked at this property. Do you know how far back that deck goes?
That takes up almost the entire back door.
Yeah, my house is diagonal from them, so I see it when I'm on my back porch.
Okay.
So I'm familiar with the property. So yes, it's much larger, and the shed was removed before they got the permit for the deck.
Yeah.
I think they've done a nice job of what they've redesigned, but I think the argument that they have to put it on the side and get a variance, there was opportunity to do a new shed in other areas, and still is an opportunity to do a shed in a different area and not need a variance.
You think that there is room in the back to do that?
It appeared to be
Okay.
based on what the design of the backyard is and the work that they chose to do in the last 2 to 3 years, there is still an opportunity for the shed to have been there today potentially, and I think before the deck was built. Yes.
Uh-huh. Okay. Yeah.
And I say all that again, saying it looks much better than it did with all the trees and things they've done. They did a great job with it. Look better.
Mhm.
Very crowded.
Yeah.
Did you say there would be space still in the back for the shed
If they hadn't extended the deck.
if they hadn't extended the deck?
Yeah. Which, as Jim's pointing out, he believes that is a self-created hardship then. They're coming to us now because maybe they didn't think about putting in a shed
Right.
at that time. But now that they've decided to have one, did they create this hardship by taking up all of their available space to put a shed in the back where it would have been within the setback lines?
True. Right.
Yeah.
So they created the hardship.
It could be argued that, yeah.
Hmm.
Mhm.
And there's absolutely no other space, I guess, no other spot.
Doesn't appear to be. Certainly not on the side of the house where they want to put it. You're not going to put a shed in the front of the house.
Right.
That's nuts. And on the other side of the house, you really can't tell how much room they have over there, but it looks to be probably about 14 feet or something like that. But your side yard setback is much less on that side.
Hmm. Hmm.
So could he fit? I don't know what he has. Does he have anything over there? Looks just like some more landscaping over there, perhaps.
So the shed is going to be 9 by 4.
4 by 10.
Oh, that's right, 4x10. Oh, yeah, you're right,
The
they do 4x10.
trees, back property line is still there, isn't it?
There are some, yeah.
Yeah, but they're limbed up.
They have been thinned out, I think is what it said.
I should definitely drive by this place.
I do as well.
That's the current condition?
Yes, I think
Okay.
so, yeah.
All right. All right, let me show you the current condition, because you probably have the old drawing.
Okay,
Their rear property line has large trees along the back. And then a privacy fence they put inside of their tree.
Oh.
okay.
Mhm. Oh,
So it looks like their deck goes all the way to their rear property line, but their fence is actually probably 10 feet inside the property.
Okay. Okay, thanks.
Was that? Just need a drone to fly out there while we're talking.
Yeah. Okay.
Hmm.
Well,
What I would just point out as a summary on that, what I just showed you is the rear property line has large mature trees that probably occupy a good 10 to 12 feet or better from the rear property line. Then they have a fence inside of that. So it gives the appearance that the backyard is tiny, but it's not. It probably complies with the 24 feet or so that the zoning ordinance would require for the deck being to the rear property line or somewhere thereabouts.
Yeah.
But what you're seeing there is that between that deck and that fence, which is a very narrow piece, it's not the distance of the property line.
so they don't have enough room.
They do if they remove the fence that was newly installed.
Yeah,
And or if they hadn't extended the deck.
deck so far. Yeah,
Newly installed,
yeah.
which is why I bring up is it
Mhm.
self-graded?
Yeah. Okay. Yeah, that's one of the drawbacks of having old Google pictures. I mean, this says it was taken in 2021, but who knows?
I think
Oh.
that's the reverse it is, by the way.
Mhm.
Yeah. Right, yeah. Yeah, they don't have a lot of room back there now to do much. And the deck isn't high enough to put something like this under it. I'm guessing.
I wouldn't think.
Surface of the deck only appears to be 2.5 feet above.
Yeah, it's pretty low. Ugh. Okay. Creator cost to be created. Well, then I guess I'm somewhat less certain of number 5 then. If this deck really extends that far back and has basically eliminated any opportunity to use the backyard for something like this that might have allowed it to stay within the setback line.
Mhm.
And is forcing them to have to come onto this side of the house now to locate it.
Mhm.
And how have tree lines, I'm not trying to direct your conversation
Yeah.
one way or the other, but how have tree lines and other existing mature vegetation played into your decisions in the past?
Well, I mean, you certainly have to take into consideration that you don't want to ask people to chop down trees to be able to put something in there, stay within the setback line. And, is it reasonable to say, well, you can just cut the first 10 feet off of the bottom of your trees to stick something up against, closer to the tree? So I don't think I would make them take down things in those situations. I would say, but that's a naturally occurring feature that lessens the places that you could put something. Um, But if you had room between the trees without having to remove them or cut them up, take limbs off, if you had room between those mature trees and the original deck when they bought the place to put a shed and stay within the setback lines, then extending the deck to take up that available yard area would appear to be a self-created hardship.
Hmm.
Because I mean, if I'm looking at this and they extended the deck after they thinned out the trees, then they took it out. They eliminated their options.
Mm-hmm.
And it is a pretty clear statement that no variance shall be granted in any case where the applicant has created or caused to be created
Mm-hmm.
a situation which would or has necessitated the issuance of a variance in order for such property to comply with this article. So there's no wiggle.
Okay.
There's no wiggle room. If they created this situation, it has caused them to have to come to us for a variance. If this deck had already was there when they bought the house, that'd be different.
That's true.
If they had left the trees in place and the trees were blocking their available area before they put in the deck. I mean, there's so many things that if they had not taken this action to extend the deck back to take up most of the back area,
Mm-hmm. Mm-hmm.
they wouldn't be on the side of the house.
Right.
Okay. Any other discussion?
That was a good catch.
Yeah. I'll entertain a motion to either approve with normal conditions or reject, deny, the variance.
I'm going to make a motion to deny the request based on the testimony that they made changes to the property that created the situation.
Okay. Do I have a second?
I will second that.
All right, we have a second. And let's see, how do we vote? Janice?
I agreed for denial.
Okay. Greg?
I agree to deny it.
Jim?
Deny.
Laura?
Deny.
And I deny as well, based on that failure of the one criterion.
Right, right.
So it's unanimous, denied 5-0. All right. Let's wrap that up then with, we'll move on to the continuation hearing.
Chairman, on that, two quick items.
Mhm.
One, you're going to have to write the decision in order on this one.
Yeah, I got your email on that. I understand.
I'm a party to it. I can't draft your decision.
Do you have an existing opinion from a previous administrative error appeal
I can get one.
that you
for
can send me just so I can see?
I'll have to go dig it.
Yeah, that's fine. Just so that I have some idea of how you've laid them out in the past, and
Sure.
just as a guide.
Sure.
Okay, thanks.
And the second thing is sometimes I get pulled into or insert myself in some of these, just providing comments like I did the last one. I'm a party to this.
That's right. You can't do that. Yeah, you can't do that in this one. Okay, so Today, we heard very little from the applicant today
Mm,
that was new. Except for the fact that they figured out that their house was insured as a single-family dwelling, which is very curious. And I also heard Mrs. Lord state something to the effect that there was a rider on something that showed it as a 1 to 4 family dwelling. Well, I pulled up their mortgage on this property and it doesn't say anything like that. There's no riders.
mhm.
And if she got a title insurance policy when she bought the property, that's a standard Alta policy, a 1 to 4 family. It doesn't mean that it's a multifamily. It just means that that standard policy can cover anything from a 1 to a 4 family dwelling. It doesn't indicate that there is multifamily. It's just the way the standard Alta forms are written for title insurance policies. So if she was talking about that, that doesn't provide her with anything either. But it was telling that they did not provide us with the insurance policy because it would have shown it was single family. But it was also appropriate for them to admit that they changed it, which, they didn't try to hide that fact.
But I'm not sure if she would have mentioned it if I hadn't said, okay, insurance was the big thing.
Well, actually, I was going to bring that up. I'm glad you did because I wanted to say, so you don't have the policy. You're not going to tell us anything about it because that was the one thing we asked from them.
Right, because I had that in my notes as the big question.
Yep.
What does the insurance policy?
And it added more credence to the argument from the city that this is not a multifamily dwelling, at least as far as the fact that the insurance company did not originally insure it that way.
Right.
As a multifamily dwelling. I don't know. We don't have a copy of their policy still. We don't even have a declaration page. So we can't, I'm taking them at their word, but we don't have any evidence other than their testimony that says, oh, it's now insured as multifamily.
As of Monday, it went to multi-unit.
Yeah. Well, you can get a declaration page from an insurer pretty quick.
Mm-hmm.
It doesn't take 3 days to gin up a declaration page. If you,
Mm-hmm.
even if you haven't paid your premium yet, they'll give you something that says, here's what it's going to be. So it's it's a shame that they couldn't even provide us with a declaration page that would have said it was being insured as a multifamily. So, I've got testimony, but I have to weigh that against the fact that we don't even have something in writing. And we have the fact that it wasn't originally insured that way.
Correct.
Sure. Now, when you've added a kitchen over the last couple of years and stuff like that, maybe now the insurer is willing to look at it that way. But how was it historically? If there was only some just generic appliances, but it wasn't actually a full-on kitchen that you would find in a separate dwelling unit.
Right.
And I know most counties, you're not allowed to use, even if you outfit it that way, you're not allowed to use it as a second dwelling unless the county approves it as a second dwelling, even if you have all the accoutrements of it. I mean, I have a finished basement that has a full kitchen. It's got a full bath. It's got everything. And yet I can't use it as a second dwelling.
That's right. That's right.
Unless I tell Frederick County, I want it permitted that way. And then I have to pay extra in taxes and all that stuff because it's now a multi-dwelling unit. I don't want to do that. We just use it mostly for recreational purposes. We don't use it as a dwelling.
Right.
So the fact that they went in and made adjustments, and we heard that the city gave testimony that it appeared that it was not a full-fledged kitchen at some point in time recently in the last 10 years or so. Also lends credibility to the city's argument that it was not a second dwelling. It was just maybe used as rooms to let, and convenience of having some appliances up there, but it was not a full-on kitchen.
And they've had so many zoning violations in the past.
And they have, yeah. And they were told 3 years ago not to use it as a second dwelling.
She kind of just goes ahead and does what she wants. It's like,
It did appear that way a little bit. And for her to say that she's a realtor for 33 years,
ooh,
you know,
yes.
I have a sister who's a realtor, and I'll guarantee you that she would have asked a lot more questions about what was going on here. If for any potential buyer of a property that she would list, if it's being used and rented as a 2-unit building, she's going to want to make sure, hey, you got permits, right? You got approval for this, right? It's zoned this way, right?
Right.
You don't just throw it out there and say, it is what it is. It's
I know
buyer beware.
I know she said she was a realtor for 33 years, but she did say that she was not up on all the laws of the, real estate. Mhm.
No, I'm not. Yeah. And I don't, that's okay. Not everybody knows everything. I'm a real estate attorney. I learn things every day about real estate law, but to buy a piece of property yourself
Mhm.
and not inquire a little deeper into, well, you're renting it. How are you renting it? Oh, it's a multifamily. Is it a multifamily? I mean, that just lends to some due diligence on your part as a potential buyer, let alone a listing realtor, but as a potential buyer to say, is this allowed? Is this really,
Right.
Does it look that way from the outside? Does it appear that way in the land records? Does it appear that way in SDAT? What gives me an indication that this is an approved multi-dwelling unit?
Mhm. Mhm.
Not just to accept somebody's say so, the owners say so, or the deceased owner's brothers say so. You can't just wade into something like that.
Personally, I think it's probably been used maybe off and on as a rental spot for a room. And
Yeah.
Something that's leading to believe that he's the non-conforming grandfather.
Yeah. Yeah, and and if we say, as Steve pointed out when he was testifying for the city, there's really 2 questions here to answer. The first was it a legal non-conforming use? And if so, then did it continue its non-conforming use, meaning it was rented and had occupants in 2 units the entire time? And there was no consecutive 2-year gap. And we had testimony from the city that between 2008 and 2011, it was not being occupied as a multi-unit because there was permits and they were doing wiring and there was all kinds of stuff, and you couldn't have somebody live there
Right.
unless you were doing it illegally. Because it would have been a hazard to have all those exposed wires and everything. And, it's not completed. You're supposed to, whenever you do those kinds of things, you're supposed to have final sign off and so that you can use it and occupy it as a second unit. So, and they did not provide, in my opinion, they didn't provide sufficient evidence. They have Mr. Haxton, the original owner or the previous owner, they had some, I guess, some back and forth text information and stuff like that. That's where he says, well, I rented out some rooms to people from this day to this day. And I said, well, did anybody sign anything? Was there any paperwork to show? Do you have rent receipts? Do you have anything to show the duration that people from when people lived to when people lived? I mean, I've handled these cases in the past and I always try to get that information. So, but we didn't see that here. We didn't see anything in writing. We just had some statements that indicated that he rented rooms and they were broad jumps of time, for 20 years.
Mhm.
From when to when.
Mhm.
Do you have something in writing? Do you have rent receipts? Do you have anything to show that, to back that up? She certainly didn't.
Yeah, because she said she didn't have any leases when she purchased the property. So she
Right. So there's no leases.
Right.
Do you have, were security deposits collected? If security deposits were collected, were you paying statutory interest on the security deposits? Do you have something to show that you gave back to those people who when they left that, I gave them back their security deposit with interest? And if you didn't, do you have something that shows, I deducted it because there were damages and so on? You got to have something more.
Right.
To show, especially when that's a critical issue, that there was continuous use for the entire time of the nonconformity, such that it would not lapse.
Mm-hmm, mm-hmm.
And they all they provided was Mr. Haxton's somewhat cryptic and incomplete statements, and his brother saying, "Yeah, this is what he did."
Right.
Well, okay, you got two people saying the same thing, and yet I don't see any real evidence to back it up.
True.
And we have some statements that, well, from time to time he would rent rooms. Well, this written stuff that she submitted from Mr. Haxton made it seem as though it covered his entire ownership of that property. He had somebody in there all the time.
Mm-hmm.
Then he said, I would rent from time to time.
Mm-hmm. Mm-hmm.
Well, that indicates gaps.
That's true.
That at some portions you didn't have tenants. You didn't have roomers in the upstairs unit or upstairs bedrooms. And so I don't know if the questioning to Mr. Haxton was sufficient enough that he realized that what he was doing is showing that there were gaps.
Mm-hmm.
And then you combine that with the city personnel's testimony that from 2008 to 2011, it appeared that there wasn't anybody living there,
Right.
other than Mr. Haxton. That's a sufficient time gap that even if we find that the non-conforming use existed, it lapsed.
Yes.
They didn't provide anything to show that from 2008 to 2011, there was somebody there for certain.
Correct.
And I know the applicant and her counsel are put in a tough spot because Mr. Haxton's gone, he's deceased.
Mm-hmm.
And he didn't apparently keep written records of things. He was just going off of his memory of what he did,
Mm-hmm.
which is okay, but not for her purposes. She needs to show something, proof positive. She needs to carry the burden to show us that yes, every gap was covered, or every time period was covered, and any gaps did not last more than 2 years.
And she really had a month to get all this together, but we
And
received nothing.
didn't provide us with anything. So that the implication or the inference is that nothing exists
Mm-hmm.
to show that.
Mm-hmm.
There's certainly nothing that would benefit her.
Even her counsel, who had so much to say, the initial didn't have much to say at all.
Yeah, I can kind of think behind his tactics on that, but the city was clear to point out that there's one trash collection account, there's one water meter, there's one electric meter. SDAT considers this to be a single unit. The city always considered it to be a single unit. They countered any argument that said, well, the city even came in and did electric work, or approved electric work, I should say. And Mr. Bachmiller pointed out that just because they permitted something and just because they inspected it doesn't mean that there was zoning approval
Correct.
given or recognition of a non-conforming use.
Right.
It just shows that it was the work was permitted, and all a permit does is says that it's being done by a licensed
Mm-hmm.
person,
Mm-hmm.
and that when it's inspected, it's been done to code. But again, that doesn't affect zoning.
Mm-hmm.
So I think that the preponderance, if not the majority of the evidence, leans towards this not being a non-conforming use. It really doesn't appear to have been used as a multi-dwelling unit. It was simply, he occasionally rented out some bedrooms
In a family home.
in a home.
Yep.
Just like anybody who has a single family dwelling might take in somebody who's on a hard time or needs some care, and you let them use your bedroom and they contribute to the household expenses maybe. But that doesn't make that bedroom a separate unit, even if it's up on the second level, even if it's got its own bathroom or its own kitchen,
Right.
it doesn't convert it into a second unit.
Correct.
Um,
I, for one, have had 5 different occasions of living in a room in a private home.
yeah.
So,
Yeah.
yeah,
And people do it now. It's Airbnb. It's all the rage. Let people live in your home
that's true.
or a portion of your home. It doesn't turn it into a multifamily unit. So I'm very reticent to grant this because or say that there was error committed by the zoning administrator, because there's overwhelming evidence that shows that it was just pretty much used as he just decided to rent to people.
Right, true.
But it doesn't rise to the level of being a separate, non-conforming second dwelling of a legal nature. And even if it did, which I'm not admitting that it does, even if it did, there was a big gap, a 3-year gap,
Right.
that they could not account for, that the city did testify and show that there are permits that were not closed out, that stayed open for 3 years and still apparently haven't been closed out because they just didn't come back and say, hey, we finished, we're doing this. And so you've got a big gap there. They never provided information to overcome. Jim, Greg, Laura, any comments?
They can't participate.
Oh, that's right. I'm sorry. So it's me, you, and Aaron, right? Yeah, Aaron. Anything we're missing, Aaron?
No, I don't have anything else to add.
Okay. All right. Janice, or do you have a motion to make for me here? To either approve the appeal for that there was administrative error, or denying the appeal that there was administrative error here?
Make a motion. I can't remember the exact verbiage. Sorry.
Are you want to approve or deny?
Deny.
Deny. Okay, so the motion to deny that there was administrative error in the situation, that a non-conforming use it either did not exist, or if it did, there was a sufficient gap for that non-conforming use to have elapsed.
Mhm.
I guess we'd say either way. Okay, Janice, you second that?
I second, yes.
Okay. All right, how do you vote? Aaron, how do you vote? Janice?
Deny.
And I also vote to deny. Okay, it's unanimous, 3-0 to deny the appeal that there was any administrative error. Okay.
Ryan, we're gonna need to get the files to you so you can write your report.
Okay. Yeah, you don't need to send them to me. When you have everything together, I can just come by and pick it up.
Okay, sounds good.
Yeah.
I gotta get you a model.
A sample, yeah. I think I'm trying to think of when I'm going to be in town next. I can probably just swing in. Today is Wednesday. I'll try to get there before the end of the week. If not, it'll probably be Monday.
All right, I'll go looking for a model for you tomorrow then.
Okay, thanks.
Okay.
All right, I appreciate everybody's time tonight.
Before you adjourn, we do have one administrative item.
Okay.
We're coming to an end of an era in this organization. And then
We are.
Recording secretary, Debbie Calhoun, is retiring as of June 30th after a long time working for the city.
Long time.
39 years and 8 months, not that she's counting.
Wow.
Although she is counting the hours until June 30th. So this is Debbie's last meeting before she retires. And we want to thank her for her decades of service to the city.
Yeah.
And
Absolutely.
keep her in my brain pants. She's bailed me out of fires more times than I can count. And her replacement has been selected and starts next week. There's going to be some overlap so Debbie can do some training.
Okay.
The new recording secretary, her name is Amy Haught, H-A-U-G-H. So she'll be in
Okay.
HAU.
H-A-U-G-H-T.
Okay.
Is she from outside, or was she a current city employee?
She currently works for one of the local utility contractors in the city.
Okay, good. Well, Debbie, thank you very much for all of your service. You've been a real joy to work with, and you've kept all of us on our toes. I've been doing this for a number of years, and you always are ready with everything. So thank you very much. I wish you all the best in the future. I'm sure that you'll enjoy retirement and come back and see us sometime.
She will enjoy retirement.
Oh, by the way, your
For that.
retirement party is on the afternoon of the
June
30th.
30th. Yep. I'll be there. All right. Thank you so much, everybody.
Okay.
Have a wonderful rest of your week, and we'll reconvene in July. If we have any. Do we have any hearings yet? Okay. All right. Take care, everyone. Bye-bye.
Okay, thank you. Good night.